Hey everybody, welcome to the show today. We got plenty of neat things for you. Let me see if I can get the back of my head back. There we go. All right. Start off by saying hi to everybody. Hey, Sivo girl, taught me how to play checkers last night. I really appreciate that. We got Linus and Fozzie. Fozzie was first, no matter what Linus says. And then we got Emily, Donald, Westerdale. Hey, how are you doing? Roll on G. Thank you for coming in. And Emily smiles. Yeah, Emily got her ice cream, so she's happy. Hey, Tokyo, how are you doing? Listening while driving. Oh, okay, shoot. Prop that phone up on the dash seat. What kind of trouble do y'all getting on over there if you get caught driving and looking on the phone? I wonder how that turns out. Roll on G she's supposed to be on a date. That's no good. Well, I'm glad you're here with us, Roll on G. All right, we're gonna go. We got some Judge Simpson and some Thurston County and Judge Kirkham and another one of Thurston County. So let's jump on a good Judge Simpson one from back in February.
Counts. The first being unlawful imprisonment.
Court calls the case People versus David Floyd. Next time, make sure to check before we go to another block with me.
Assistant prosecuting attorney William Rose on behalf of the people.
Assistant Public Defender on behalf of Mr. David Floyd. Mr. Floyd, please state your name for the record, please.
David Floyd. All right. This is People's motion.
Yes, Your Honor. At arraignment on Tuesday, the defendant was given a PR bond. The defendant was arraigned on 4 felony counts. The first being unlawful imprisonment. The second, third, and fourth were 3 counts of strangulation, all against the same victim. They occurred over an extended and prolonged period of time at multiple different locations with at least one independent witness who called and reported the incident. Another witness who did make a statement to the police was the victim's 16-year-old daughter. And in fact, during the last strangulation, which occurred in the home, the only reason that the defendant stopped was because the 16-year-old daughter yelled at him to stop strangling her mother. We had requested, I'm trying to find my motion now, Your Honor, but we had requested, I believe it was $200,000 at the cash or surety for a bond amount at the arraignment. And over our objections and bond argument, the magistrate gave a PR. Beyond the particular facts of this case, we are concerned about the defendant's criminal history, which includes a 2001 conviction for armed robbery, a 2007 conviction for felony firearm, a 2011 conviction for firearm possession by a felon, which was enhanced with a felony habitual third offense notice, as well as he did have 2 felony domestic violence cases in 2023. Both of them ended up being dismissed in December of 2023, and they were with the same victim. I do want to put on the record that we are concerned because it appears that during arraignment, part of the reasoning for the PR bond was that the victim did not appear and that was why those 2 felony domestic violence cases were dismissed in December. And according to my arraignment attorney, the statement by Magistrate Fink was that there's nothing in the record to indicate that that was at the hand of the defendant. Additionally, we are concerned because prior to arraignment, the defendant made at least 1 jail call to an unknown number where he provided the victim's phone number. to that unknown male. And he indicated to that unknown male that his mom needed to call the victim, talking about some belongings. He made the statement, "I did some hoe shit." All in all, the seriousness of the offense charged, the fact that it was in multiple locations over a prolonged period, there were independent witnesses. And not just independent witnesses, but a minor child who had to intervene in order to get the defendant to stop, as well as his criminal history, gives us serious concerns for his danger to the community as well as to the victim is if he is out.
Thank you, Judge.
Mr. Pfister.
Obviously, I was not the attorney at the arraignment yesterday, but hearing what I've heard today and reading the notes in the file, I have several things I guess I want to touch on, Judge. First of all, being that nothing has changed today that wasn't said yesterday at the arraignment. Magistrate Fink heard all of these arguments and in her infinite wisdom made the decision to give the client a PR bond. Now we're asking for the defendant to have a $200,000 bond. So if anything has changed, nothing has changed in the nature of $200,000 to where his bond should go from a personal bond to a $200,000 bond. Additionally, my client's last convictions, if I heard correctly, were in 2011. So there's been 13 years since he's had any conviction that I have heard of at this point, Judge. Additionally, I don't know whether or not the complaining witness appeared at the arraignment, or if she didn't appear at the arraignment, whether or not Magistrate Fink weighed that as determining client's bond. But what I do know is that the complaining witness apparently did not come to some dates in 2023. She is not here today. We don't know if she'll be here at preliminary examination. So I'm sure Magistrate Fink did consider all those things when setting the bond. And the other thing that the people argue in their motion, and I believe it's number 12, is that my client made a phone call to a male and told that male to call the complaining witness. I would disagree with all of those statements in that number 12. If you look at the police report, the phone number listed for the complaining witness is not the phone number that the client gave to the male. That phone number is listed as a secondary number for the complaining witness and another primary number for the 16-year-old daughter, his stepdaughter, who he does not have a no contact order with. So I do not think that that is stated appropriately, that my client tried to reach the witness through a third party. I think that is, if you go get the phone right now, it is not in the complaining witness's possession. The complaining witness never has that phone with that phone number. That's the number ending in 9827. That number will be in the hands of Kayla, the 16-year-old stepdaughter. And so that is not my client trying to make contact with the complaining witness in any way. So I disagree with that statement completely, Judge. So in summary, what I'm saying is that there have been no changes from yesterday. There are no calls to the victim. There are no attempted calls to the victim. There is no reason why the bond should go from a PR bond to a $200,000 bond. I'd ask the court to maintain the bond where it is. Mr. Floyd lives in Detroit. The complaining witness lives here in Glencoe. If the court wants to give Mr. Floyd a tether, which he was given yesterday by Magistrate Fink, was a high spot not to go to Glencoe Hills, that's fine. If the court wants to give him a tether, with him not to come to Washington County, that is fine. He has no reason to be here. He has no reason to have any contact with the victim, the complaining witness in this matter. He does have 2 minor children that he has parenting time of every weekend. He lives in Detroit. He works in Detroit. He's starting a new job in Detroit on March 18th, in Pontiac on March 18th at Amazon. And so I don't think there's anything that's new here, that's been said here, that should change the defendant's bond from a personal to a $200,000 bond, Judge.
Me. As I understand, at least the facts that have been relayed to me, at some point, some of these activities are occurring in the proximity of the children. There were 5 children that are there at the apartment, right? And again, it's just my impression by this, that the 16-year-old is yelling stop, but these children are still in that vicinity.
That is correct, Your Honor. The victim's 5 children were sleeping in the residence, including the 16-year-old minor child when this occurred in the residence.
Okay.
That's my understanding, Judge. There were 5 children in the residence. All of them asleep except for the 16-year-old,
Okay.
who is the oldest.
Okay. And so part of what concerns me is I don't understand. Let's just take the 16-year-old, leave the others aside. With the 16-year-old, I don't know why I don't have no contact with her.
Fair.
Right?
Okay.
So that's one thing. I guess I should preface all of this by indicating, counsel, I reviewed the video of the arraignment, which I do customarily with these motions, so that I can be clear as to what's there, because everybody's thinking certain things are said, or not said, whatever. So I have an issue with that. I also was trying to clarify the 2 children. Are those 2 of the 5, or are those other children?
Other children.
Okay, so with the 5 children, is there any reason this defendant would need to have contact with them?
So he's married to the complaining witness in this case. Those 5 children are her children. He considers them to be his stepchildren, but he does not have to have contact with them until this matter is resolved.
All right, that's one thing. The other thing, in terms of the monetary amount of the bond, again, as I'm to at least understanding the facts, there are numerous events occurring at various places. Part of the difficulty that I'm having is that at arraignment, public hearing the allegations, or at least seeing part of the allegations, at least as described by, well, wherever they may have gotten their information, maybe they would have gotten the police report or part of the police report, I don't know. But even the public defender appearing for the purposes of arraignment did not request a PR. And so that gave me great pause. I'm not saying that it's got to be the number that the people want, but I think even able counsel is, in looking at it and being with candor to the court, given the circumstances, it wasn't asking for a PR bond. And then a PR bond gets set. So I have issues with the fact that the children weren't included in the no contact. I also have issues with nobody was requesting a PR and a PR gets set. Certainly the magistrate within their discretion could do that. But my firm belief is that and in looking at this, and I mean, I always hate saying it, but it sounds to me like it's an abuse of discretion in terms of the bond that is set. And so for purposes of rectifying all of that, I'm going to make that finding. And I'm going to reset the defendant's bond in this case. And again, Mr. Feaster, I think it, in terms of making this argument, you've seen at least the police report.
Yes, have judge, yes.
All right. Anything else? I am going to set a monetary bond in this matter. Anything else?
No, judge.
Given the circumstances and looking at it, I will order, I need the names from, you can provide those so that minors' names don't go out, but you can provide those to my court staff and we will include them in this order. I will set the defendant's bond at the amount of 50,000 cash surety. In this case, the tether provision, should he post, would continue in this matter. All right. Well, let me do this. Is there a reason, if you posted, is there a reason for you to be in Washtenaw County at all? All right. So we'll need an order. I'll amend the GPS provision so that, sir, you can't enter Washtenaw County. Okay, so I would amend that provision. I just, if you're out and then if you're driving around, just be where people mess up. And I try to let people know this so that they don't do it. It's just the highways, because sometimes you cross over and then it would go off. Okay. So I will sign an order to that effect so that if he gets out,
Thank you.
can't be there, can't have contact with any of the, which you're referring to as the stepchildren. All of the other conditions that the magistrate put in place would also remain in place that aren't inconsistent with what I've ordered.
Okay. Thank you very much.
All right, thank you.
Call me. I can reach out to get your keys and the rest of it.
Yes,
Oh.
I don't need a signature.
Well, you can see a difference with Mr. Allen and that deputy or bailiff. I'm not sure what they call him there, but you can see with Mr. Allen, he'd have been hanging up behind his back and going, and that fella there had his hand in his pocket during most of the time. Hey, Big Chungus, how are you? We got a whole pile of more people. LD, how are you? That's my brother. I'm going to mention that every time. All through life, everybody was wondering about his name just being 2 letters, but that's how he was cursed. Looking through. I'm gonna say hey again to Sivo girl just because. Get Jay, Terry Barnes, throw the goat. So I didn't know anything about Discord until I wanted to get into Kathy's Discord, just kind of get some of the energy and see how Kathy does things. Because in the end, I look up to her, and so I go over there. And one day they have a voice chat, and I get in there and throw the goats in there. And she has the greatest voice. I didn't know where she was from, but as soon as you get to talking with her, it's obvious where she's from, and just has the greatest accent. So if you ever get a chance to chat with her in there, definitely jump over there. So we're going to jump over to a Thurston County case. I called this one Justice for Justice. The fellow's name is Justice, and he's sitting over there with his wife, and she's arguing back and forth with her boyfriend, and it's just embarrassing for him. I don't even know why he showed up in court, but it's an entertaining clip. So here we go.
Mr. and Ms. Justice,
Yes, Your
you
Honor.
come on the Zoom call, and then Mr. Richard is here as well. Give me just a second to transfer over to that case. Okay, so of the Manas, who's going to speak first?
I'll speak first, and then my wife will fill in the gaps, Your Honor.
Okay. Could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. How is it you need an order against Mr. Richard?
Okay, I'll start from the beginning.
That's a good place.
Okay. So there was extramarital affairs between Mr. Richard and my wife. Mr. Richard and myself were in the armed forces. He was active duty. I was National Guard. So I came to find out about the extramarital affair, and I contacted my superiors to find out what the best course of action would be. So an investigation was started on Mr. Richard. We were interviewed. He was interviewed, and a no contact order was initiated between Mr. Richard and my wife. Since then, Mr. Richard has gotten out of the military. And just after he got out of the military, he decided to visit my premises or our premises, where we do have several vulnerable adults. And he was seen on camera, and there's a video recording of him knocking and asking for me. And just to take a step back, when he got wind that I was going to start an investigation, he mentioned that if I did go through with starting a investigation on the military side, he would pay me a visit, so to say. So when he got out, I think of just to illustrate how calculating Mr. Richard is, he decided to find an apartment minutes from our house, and he's been to my residence in the past. So he found an apartment right next to our house, and then he decided to show up to our doorstep and I guess start asking or looking for me. And at that point, you know, I reached out to our military supervisors or superiors because we didn't know he was out. And so they say there's nothing they could do since that was like a military no contact order, protection order. And they advised us to pursue things on the civilian side. And so that's when we decided to reach out to the Lacey Police Department and find out what we could do to protect ourselves and our child and the people who live at our residence as well, because he just doesn't seem to want to move on or to continue with his life. So we were granted the temporary protection order, and then we were required to show up today to have a court hearing. My wife can, you know, add in the pieces where I've left out.
Ms. Mena, could you raise your right hand, please? You swear or affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead. What's your position on all of this?
Well, the last time that I had contact with Mr. Richard, I asked him to just let me be, let us be, to let it go. I knew that he was upset because my husband was seeking information on how to go about investigating the fact, because he was a sergeant in the military. So I know that he had put a lot into his career, but he has 5 kids and we have a 1-year-old. And so I kind of just reminded him to just let it go because we have kids and it's not worth it. Like what has happened in the past has happened in the past. It's not worth the stress. And I'm also pregnant now. So I don't want him just showing up or thinking that he has a place. Like I don't feel like a
Did everybody hear that? Now that she's pregnant, she wants to break up with her boyfriend. And so, you know, it's honorable for her to want to stay with her husband now that she's pregnant. So got a biggin raid coming. Thank you, everybody. Thank you. We're going to give it a second, let everybody run in to hear the rest of this fun story. Look, we got Kiki Blue, Kimby 63, Pebbles, Peepla 7. Hey, Peepla. MN Kid 25. Taria, Okay, now we got too many. I'm not going to be able to keep up with any of this. K. Sarah. This is a Taria or Taria. How do you say it? How do you say that? Taria Sumler. How do you say that name? Metal Rabbit. Good to see you. ATX Alley. It is weird seeing Gray. You need to talk to Jay about that. Talk to Jay about that. She'll see what she can do about that one. Got a whole bunch of them coming in here. Thank you, Biggin. Like I mentioned before, whenever I first started the channel, Biggin was always supportive of the channel. So I really appreciate all that he's done for it. I like watching his channel. He does a little bit different. His channel gives me anxiety sometimes getting to see all my exes on there. All right, we're gonna jump back into this one. Just to catch everybody up, it's a protection order. The loving couple on the left are a married couple. Now they're pregnant with kids, or she's pregnant with a kid, and she doesn't want her boyfriend, the fellow on the right, to keep bothering her. So she's hoping for a restraining order to get him to get the hint to leave it alone. She ain't worth it.
Conversation needs to be had, like what has happened. He was also married, and we took two different approaches. And so I'm concerned about the safety of the people that live at the house, because I know that there's emotions involved, but also I'm again worried about our families.
The amount of emotional stress that it's caused my wife and I is tremendous, to say the least. We just want the guy to stop and to move on with his life, which he seems to have a hard time of doing. And I don't think it's an accident that he decided to choose an apartment minutes away from our house, or I don't think it's an accident that he decided to show up at our premises, at our door, immediately when he got out. It's something that he has been thinking about, something that he's been patiently waiting to do, which is what is worrying us, because we don't know what else to expect. I think it was fortunate that I was not at the premises when he showed up. And to me, I thought, it's something that the protection order was put in place, I think September, October last year. I thought that would be the last time we would hear of him. But he just seems vengeful.
Let me hear from him, get his perspective on this. So, Mr. Richard, could you unmute, please?
Yes, sir.
And raise your right hand. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. What's your perspective on what they're requesting?
Honestly, I think it's not warranted. Josie and I kind of made a plan to be together when I got out, and then they got married or whatever. Even with the military, like, no contact order side, she was still contacting me. She would still call me. And throughout this period, even when they went to Canada, she called me after getting back. In October, I left for a training event about a month long. She did contact me then. After that, the next time I believe was March, as early as March 27th. And I just wanted to have
March
a
27th, as in like a month ago?
Correct, sir. I just wanted a man-to-man conversation with justice. That's really it. I have no issues like letting it go. That's like whatever, like they go, be happy. I'm happy where I'm at. And the whole reason why I chose this place is just because it was cheaper rent.
So Ms. Mena, Mr. Richard just told me you're reaching out to him as late as a month ago?
He's been in contact with my coworker, my boss. He's been messaging my boss, and my boss has been telling him, like, he asked her, should he move down to Lacey Olympia area to be closer to me? Like, is the plan still on? And she did not give him any indication that he should move down that way. She's stuck to exactly what I've said. I'm married. I made my decision. That's who he's been in contact with, is my boss.
Guess the question is, do you have contact with him?
Yeah, he's telling me that you reached out to him, is what I heard.
No,
Okay, and so Mr. Richard, how did she reach out to you? Like a text or?
Block number and then an Instagram account. Do you want me to share my screen with you?
I don't know that you can. The Instagram, what did the Instagram, I mean, what was the nature of the reaching out?
It was harmless. It was about a song.
How close do you folks live to each other?
he literally moved in the apartments behind. It's the same block.
And you're out of the military now there, Mr. Richard?
Yeah, I am. I just work and go to school.
No.
I didn't. What
Okay,
was
so
the question?
hang on, ma'am, we're on the record here.
Okay.
You were gonna say something though?
No, my husband said that you had asked me a question. I said I didn't hear the question.
How long has the military order been in place?
Since the end of September.
When did you get out of the military, Mr. Richard?
The 3rd. And
Of April?
the 3rd of April, sir. And I did tell Josie that I would stop by after I got out to apologize to her dad for everything, and then also just want to talk to Justice, man-to-man conversation. That's it.
When did you tell her this?
Called her in the summer, over the summer, September. Last month when she called. And
She's saying she called you on a blocked number?
yeah, she would always call on a block number, sir.
And Ms. telling me this didn't happen.
No. He has said it in the past. He has said that he was going to come back. We did have a plan. He was going to leave his wife, but that started
So
2
hang on, no. I'm not talking about that. I'm not talking about. Okay. Hang on just a minute.
I'll jump in while the judge is being quiet. Man, you could see the frustration on his face. You know, he just imagine having to deal with people's craziness like that. It's bad enough that people deal with it, but you know, having to have a referee. If nothing else, I try to stay out of trouble just so I don't have to have a referee. I'd hate to have someone else be my adopted stepdaddy for the foreseeable future. So when he gets done seeing the craziness here he goes.
What song, Mr. Richard, was referenced?
Same Way. The song name is Same Way by Milo XO.
Okay. So here, I'm going to read the definition of harassment to all three of you here. And so these are anti-harassment orders. You know, there's certain things I need to find in order to enter an order. And here's the definition of that: is a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person and serves no legitimate or lawful purpose.
Hey, ATX Alley, I will give you a quick recap. I'm trying to get Tokyo to jump on the chat with me. Can you imagine fighting over oh, LD, that was just mean. I'm trying to get Tokyo to jump on with us. He's gonna try to see if he can't jump in. So a recap: the beautiful couple down on the bottom left, loving, happy couple, expecting a child, has a problem with the boyfriend on the right who moved into an apartment complex. She said it was the same apartment, but now it's on the same block, so she's not right there. And the boyfriend, I guess they're sending songs to each other, just showing how much they love each other. And so they're doing that. Give me just a second, guys. I'm gonna try to get I'm gonna make a smart decision and jump off. Tokyo's not going to be able to join right now, so I'm going to go ahead and finish this up, and I'll explain in a bit.
The course of conduct must be as such would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner, or a single act of violence or threat of violence directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person that serves no legitimate or lawful purpose. So it can be a single act. It can be a series of acts over a period of time. And if you were paying attention to that case that we just had here, we had a case where one person, and I have to, it's not uncommon for me to hear two different versions of, the same set of facts, but basically one person said, I'm going to come and, kick your head and kick your certain part of your anatomy, as well as other things, which I found to be threatening. And so I entered an order. With regard to this case, and again, the military, they may have their own standards, but listening to all three of you at this point, I don't find, and I don't sound any allegation that Mr. Richard has made any sort of threats or threats of violence or anything like that. It does make me scratch my head a little bit that he's moving close to you, but that's not a threat of, may make you uncomfortable given the state of your relationship, but I really can't find that's, a threat of violence at this point. And so, and he did come over at one point, apparently there is evidence of that, but again, coming over to talk or hash all this out and talk man to man, that's not, again, I just can't find, it's a long way of saying I can't really get there from here. I'm not going to enter an order at this case based on what's alleged. Now going to you, Mr. Richard, again, even though that I'm finding that it's not harassing now, that may change if this continues. So it doesn't have to be a threat of violence. It's a course of conduct directed at a specific person which seriously alarms or harasses. So if you keep showing up, you keep bugging them or trying to reach out and communicate, then, my position on this might change, whereas I would find that harassing. Do you understand that?
Understood, sir.
So folks need to stay away from each other. And so again, I'm hoping that you're both getting the message here right now. So based on what I have heard so far, I'm going to deny the order to extend the order. And but again, if this keeps up, Mr. Richard, again, I can tell the maintenance, you can come back and then we'll take a second look at it. And maybe we come to the point where an order is appropriate, but I'm not going to do that now.
All right, sir.
You understand? Everybody on the same page?
Zero.
Mr. Richard, do you have any questions about whether or not the maintenance want to hear from you at all?
Oh, no, they won't, sir.
Okay. That's it for today. You can get a copy of this off the Thurston County District Court website.
There's something in there, sir, about like legal fees or something of,
I'm not awarding that.
okay. Is that, you're not awarding like all
That's
fees?
it. You're free to, you're all free to leave the Zoom call.
All right, sir. Thank you. Have a good day.
There again, like I mentioned, imagine having to go to a government officer to tell you to leave each other alone. Everybody's talking about they think she's jumping the fence. Absolutely, she's jumping the fence. There's no way in my mind that she didn't do this just to prove to him, that she's not interested in him. But I bet if you checked his phone, you'll see a text within the next 30 minutes to him. All right, we're gonna go on to Judge Kirkham, and then we'll see what we'll go from there. I think the last one's another Thurston County one, but here's Judge Kirkham.
There we go.
Okay, thank you. Mr. Karras, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do.
The Court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, I have.
Mr. Sackrider, are you ready to proceed?
Yes, I am, Your Honor.
Okay. Mr. Karras, Ms. Brown's previously been sworn at another hearing. I'm gonna have you raise your right hand and be sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay, thank you. You can put your hand down. Ms. Brown, you can proceed.
Thank you, Your Honor. Mr. Karras is before the court on two matters, docket 2012-2635 DS and docket 2019-2015 DS. On the 2019 case, the parties are married and the total arrears owed on that case is $347.97. The 2012 case, Mr. Karras has a monthly obligation of $267.50. His last payment was October 6th of 2021. That was $68.04 through an income withholding with unemployment. He's had 4 prior contempt findings. For 2 months of compliance, Mr. Karras should have paid $535. He's paid nothing. Total arrears on the 2012 case is $18,765.50. Friend of the court would like the court to be aware that the hearing today is actually a compliance hearing. He was before Your Honor on February 24th. At that time, you adjourned the matters to monitor Mr. Karras's Social Security claim.
Okay, hold on, oh, there it is. I get my notes from that other hearing. Okay,
yeah.
Go ahead.
Since that hearing, friend of the court has not been able to confirm that Mr. Karras has even applied for benefits. He has also failed to submit medical documentation to our office repeatedly. So here we are today. That's all I have.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Brown?
No, Your Honor.
Okay. Any questions for Ms. Brown?
No, Your Honor.
Any proofs?
Yes, I call Mr. Karras.
Okay.
All right, Mr. Karras, you heard the testimony of Ms. Brown. Is there anything that you disagree with?
I got paperwork in the mail from the court saying that I only owed a total of $770 on Caitlin. And it was like $441 at the time on my case with Elijah.
Okay. And who are those papers from?
The courts there in Battle Creek.
Okay. And what do you take those papers to mean?
That's all I owe. It says in total I owed what was the total of those two amounts, and that was it. It didn't say nothing about 18,000 or nothing else. That's all it said I owed.
Okay. Ms. Brown testified that this was adjourned for you to provide medical records. Did you hear that testimony?
Yes, I did.
Did you provide medical records to Ms. Brown?
I didn't even have a doctor at the time. I just now got insurance on the 1st of the month, so I could go and get scheduled with a doctor. They're scheduling out way out months and months now, and I've got one set up for the 1st of the month.
Okay, what is your disability or injury?
I have shoulder injury, neck injury, and back injury.
All right, are those preventing you from working?
Half the time I can't even walk. My left leg goes numb, it gives out on me, and then I'm for a day or two I can't feel nothing below the waist.
All right, when was the last time you were employed?
Back right before the car accident.
When was that?
2002. I mean, no, 2022, sorry. Duh. Sorry.
All right. You filed for disability?
Yes, I have.
When?
Like 3 weeks ago, I think it is.
All right, do you have a lawyer helping you with that?
Not at the time. I don't.
All right, how have you been supporting yourself?
I haven't been able to do anything. I'm stuck. No way to get around, no way to do nothing right now.
Do you have an income?
No, I do not.
Have you been applying for jobs?
If I can't walk, how am I supposed to do a job?
All right, where have you been living?
With a friend of mine.
Okay. Are you a veteran?
Yes.
Have you applied for any VA benefits?
Yes, I have, and they, for some reason up here in Michigan, they cannot find my file, but if I go down to Virginia and get my file, they find it.
All right. So you are eligible for benefits?
Last I knew I was.
All right. Did you post a bond at this matter?
Yes, I posted a $400 bond for the Janet Shepard case, and then I posted a $100 bond for the Monica Karras case.
All right. It was your testimony that your daughter Caitlin does not live in the state of Michigan. Is that correct?
Yes, she doesn't even live in the state of Michigan.
So she does not. Does she stay with Janet Shepard?
No, she does not. She lives with her brother on a military base down there.
Okay. Are you willing to file a motion to have that support modified?
Yes.
All right. Anything else you would like to tell the court?
I'm trying to do everything you guys want me to. I'm sorry it takes so long for the medical out for them to get up here where I'm at. But I am trying to follow with what you guys want me to do to show you the proofs and everything.
All right. Thank you. No further questions.
Okay. Mr. Karras, from the last hearing, I have my notes, and when you were asked at that time as to why you were disabled, you said you had an injury to your left thigh. You did not mention your shoulder, neck, or back at that time. Why is that?
It's my whole lower section, my hip, all across my lower back. It's the whole lower section, my hips and everything.
Did you simply forget to mention your shoulder, neck, and back the last time?
Yeah, actually, I did, Your Honor.
How have you supported yourself if you haven't worked since 2022?
I had a lawsuit. That's where I thought I thought all my child support. I got the paperwork from you guys saying that I only owed so much because it got taken care of from my lawsuit. That's what I thought. That's what I was told. Is anything from child support would come out before I got my money.
Okay, it might tell you that it would come out, but it didn't say that they collected anything at this point. Is your lawsuit been resolved?
Not if you guys haven't got your portion, because I didn't even receive nowhere near the amount they said I was going to. And I tried to call this law firm and now they won't answer the phone at all.
Ms. Brown, you didn't mention any lump sum from any action. I would assume you haven't gotten anything.
Nothing, Your Honor. We haven't even sent out a lien to an attorney. I've never been provided any of that information about a lawsuit. We haven't received a lump sum payment. There hasn't been a lien established. It's been we're approaching 3 years that I've been requesting medical documentation from Mr. Karras, and he's never submitted it. So there's a pattern of him stating that he has injuries, but there's never been any verification of any of that to our office.
Mr. Karras, in the 3 years, why haven't you provided that medical?
I did send in some documents of some work of my doctor signing me off work saying I was not able to work. And the court, and then I got told that those weren't good enough. And they were directly from my doctor.
Okay. Anything else that you'd like me to be aware of, sir?
Not that I know of. Not that I can think of.
What's your education background, sir?
I have my GED and then military training.
Okay.
I also have vocational school, an electrician's vocational school.
Your Honor, may I?
Yeah.
Yeah, I overlooked this initially. So there is a cost recovery request from the sheriff in the amount of $74.38 associated with the bench warrant back in February when Mr. Karras was before the court. So
Okay.
we'd like to address that today.
Okay. Anything else, Mr. Sackrider?
No, nothing further.
Okay. Court will make the following finding in this case. Mr. Karras has appeared. He did appear previously before the court back in February. The court adjourned the matter to today's date to give him an opportunity to do a number of things that he could do. He stated that he was pursuing some disability. We haven't received any information about that. We haven't received any information concerning his medical situation. He claims he was injured back in an accident back in March of 2022, so it's now 2 years post. We haven't received any information about that. He said he submitted some medical information, but it was not sufficient in this particular case. That's not unusual where doctors will submit something, but it doesn't delineate what their disability is or the time off or what their limitations are. And he was informed of that, but he hasn't followed up and gotten anything. In fact, he said up until just recently, he didn't even have a doctor and he didn't have insurance. That he did. Now he set up something for the first of the month. He also noted that back in February, when the court asked him as to his disability, it was with his left thigh. Now he's stating that his injuries are to his shoulder, neck, and back. That he does have GED. He has also electrician vocational training in this matter, but he simply hasn't worked since 2022. And He's well aware of the support obligation in this matter. Court will find that he's not made a good faith attempt at compliance. He's failed to refuse to comply, and therefore he's in contempt of court. Anything before sentencing, Mr. Sackrider?
Your Honor, you heard testimony from my client. He is a veteran. He's been struggling essentially with homelessness. He's staying at a friend's. My client, I do believe, is eligible for benefits. However, he doesn't have the means or the wherewithal to obtain them. We would ask that if the court does impose a jail sentence, the court set a purge amount in the amount of $100, Your Honor. Thank you.
Okay, thank you. Court does note that he had 4 prior contempts findings on the one case, and the other he had 0 prior contempt findings. The court is first going to order that you reimburse the sheriff transportation costs of $74.38. The court would forfeit the bonds previously posted in this matter. The court is going to sentence Mr. Karras to 45 days in jail with credit for no days served. The court would order that he report to the sheriff no later than 4:00 p.m. on April 26, 2024. Sir, if you don't report at that time, you could be sentenced to a greater period of time and serve, in fact, more than the 45 days. The court would allow him to purge himself of contempt by paying the sum of $500. So if you're able to pay the $500 before the April 26th date, then you would not have to serve the time in jail. Do you have any questions, sir?
No.
Okay.
Your Honor, I do have a question. So the $500 purge is on the 2012 case, on the case where he is married to the respondent and the arrears are just over $300.
I'm putting zero purge on that.
Okay, just to be sure. Thank you.
Yep. Okay. Thank you. You're free to go. Have a good day.
Hey everybody, I keep seeing new names in there. I want to say hi to everybody. Lisette, Panay. I'm horrible with names, so y'all gonna have to forgive me. Marlene, Dane Piglet. I'm gonna have to take an English class before I get any better at this. But anyways, thank you guys so much for coming. I got one more video for you. I see the comments about this public defender here, and I just tell you, he is completely defeated. Every time he's on here, he is just sad as could be. You know, imagine your whole job is to defend people that aren't paying child support. That's just a rough day, because you know this guy here, if he's disabled, he's disabled. They say he's a veteran, so I'm going to give him that chance. I'm going to give him that shot. But somebody's got to help him. There's got to be some social worker that just, holds his hand or holds the back of his neck and makes him fill out the right paperwork. If nothing else, so that his kid can get taken care of. So, all right, we're going to jump on to the last one. Thank you guys so much for your support. I'll make sure to send Big in a note later. I really appreciate you guys coming by. I'm not the best reader, not the best speaker, but I'm gonna certainly get better at it. So let's go back to Thurston County for one more.
This ends here in the courtroom. This is case 24-77, and Ms. Penn, you can go ahead and have a seat right there. And Mr. Armstrong is here with us on Zoom. Okay, just bringing up my electronic court file here. Okay, are both of you ready to go ahead with this case?
Yes, Your Honor.
Mr. Armstrong, you ready to? Okay. All right. Can I have you both raise your right hands, please? And do you both swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes. All right, thank you. Okay, same procedure as before. Ms. Penn, you get to go first. Keep in mind that everything that you previously filed in this case is already part of the record, and I'm familiar with it.
Okay.
Okay, so go right ahead.
We were in a relationship. There's a history of domestic violence. I was out of the country, and on my way traveling home, and he was just blowing up my phone with threatening messages, saying if my house wasn't connected to someone else, he was going to burn it down. He reached out and harassed my neighbors. I don't feel safe. There is a history of domestic violence, a pretty extensive record at that.
Can I ask you, in your petition, you refer to prior domestic violence orders. Are any of those orders still in effect?
No, no, because I was stupid. I came back and was like, oh, I don't need it. And then it would happen again. And he would say, oh, it's not going to happen again. So, I mean, I have photos of bruises all over. He's destroyed my great grandmother's dining table. It's just, it's not safe for me. We have no ties whatsoever.
Okay, is there anything else you want to say in addition to what you've already told me in writing, so to speak?
Not that I could think of.
Okay.
Just.
Okay. Mr. Armstrong,
Yes, Your Honor.
what would you like to tell me?
Okay. She's contacted me about getting the divorce finalized. Okay. And she asked me, Your Honor, she says, give me $200 so that way you can go half with me, and I'll get the I'll file the divorce. I said, okay. Oh, Your Honor, I had no idea that she was going out of town. I had no idea. Okay. And I to my better judgment, you know, I gave her the benefit of the doubt, you know, and gave her the money. I sent her the money. And I say probably about 2 or 3 weeks, 4 weeks went past, and she never did anything. She never, you know, and come to find out, she went out of town, you know, and I'm pretty sure she used the money to do whatever, you know, and she wasn't living up to her word on that. And not only that, you know, I had purchased a car from her. Okay, I gave her $4,600 for this car, and it was a verbal agreement. Of course, she has a ledger of, you know, I paid her money for this car, you know, and I used the car faithfully. And so something told me to go out there that day, and I went out there, and I went to the courthouse to see if she had filed for the divorce, and come to find out she never did. And I mean, I went past her house. I text the neighbor, you know, we're still pretty cool, you know, and I just asked him about the car. That was it. As far as me threatening her, I will never hurt her or any of her family. Okay. First and foremost. I was upset. Granted, you know, I shouldn't have done that. And I apologized to her. And I apologized that same time in frame, you know, when I sent those messages. Anyway, Your Honor, I just, you know, I'm just overwhelmed with, you know, the fact that, you know, I have bent over backwards for her, and I'm just trying to move on, man.
All right. You know, unlike other cases I've heard today, there's prior history here between these two parties, and I have seen, because I can check the records, I've seen that there have been prior criminal cases, there have been prior domestic violence orders issued in those cases. I've reviewed, of course, the petition that Ms. Penn filed and the allegations that are in there regarding the threats of harm, some of which she recounts here today. I find that those allegations are credible. I think a reasonable person in Ms. Penn's position would feel threatened by those statements, especially given the overall history that has been described by Ms. Penn and the history that's on record here in the court system. Those acts, those threats to do harm, to harm the property of Ms. Penn are themselves acts of domestic violence. I'm finding by preponderance of the evidence based on the testimony here today that they occurred, and they provide a basis for issuing the order that Ms. Penn is requesting. And so I'm going to do that. I'm going to put that order in place for a period of 2 years.
Goodness.
All right, this domestic violence protection order is in effect for the next 2 years from today's date, March 25th, 2026. The court clerk will file that today, and you'll both have access to that order.
So I can get copies.
You can get a copy right now
Oh,
since you're here.
Thank you, Your Honor.
It'll be filed electronically, and Mr. Armstrong can get that from the court clerk anytime. And then the next case will.
All right, everybody. That's it there. But this, yeah, absolutely, Pebbles. I see that getting Ike Turner vibes from him. He is completely comfortable with what he did. He's completely happy and feels he did the right thing. I don't know how you try to burn somebody's house down and you don't have to appear in front of the jail in handcuffs. I don't know if he's got a criminal case involved, or in the end she could have been telling a story. I don't know. Right now, anything she says, I'm gonna listen to, if nothing else, just by the way he's acting. There's a lot of conversation about that last fella. If they're a veteran, we should give them an extra 2 or 3, 4 social workers. I don't care what it takes to help veterans, but you can't fix stubborn. You can't fix somebody who's just not willing to help himself. And the way he treated the judge, no social worker deserves to be treated like that either. So, there's so much going on here. I was looking for somewhere to raid. I was looking for somewhere to go, and as I'm looking, I'm seeing that there is a political convention going on tonight, and I like to play jokes, but I don't think I'd play a joke on you guys and send y'all to a convention tonight. So I'm gonna go ahead and cut it loose. I greatly appreciate you guys coming out tonight, and I really appreciate all the people there. I see a lot of names that I haven't seen over here, but I've seen in other chat rooms. I've seen them in Collins and the different judges during the day. And so I really appreciate you guys coming out, and y'all have a good day.